My name is Lacey, and I am a representative of ABLE Law. I'm here today to talk about your rights and the ways that you can prepare in case of interaction with ICE or immigration. If immigration officers detain you, it can feel like your whole life stops in a single moment. You may feel scared, alone, and unsure of what to do next. But both in detention and in immigration court, you have rights, and knowing them can change everything. If you're in detention, remember that you have the right to be treated with respect at all times. You have the right to read the detainee handbook, access legal materials, and speak with your attorney. You can make phone calls, receive visitors, and send or get mail. You have the right to recreation, to keep your personal funds and property, and to receive medical attention when needed. And you should be able to practice your religion freely. In detention, officers may hand you forms and tell you to sign quickly. Those papers can affect whether you stay, leave, or give up important rights. You do not have to sign anything you do not understand or do not agree with. If you have never been deported before, you probably have a right to a hearing with an immigration judge about your case. Immigration detention centers have rooms where you will meet with your judge by video. You have rights in immigration court, and it's important to know them. You have the right to an attorney or to represent yourself if you choose. You can cross-examine or ask questions of anyone who testifies against you and review any documents presented in your case. You have the right to see the full record of your proceedings. This can include recordings of your hearings or information your attorney or ICE has sent to the court about your case. If you don't understand what is happening or what is being said during the immigration court, you can politely ask the judge to explain it to you. You should never agree to anything in immigration court that you do not understand, even if the judge pressures you. It is important to review your notice to appear, NTA, very closely before admitting or denying any allegations in the NTA. You have the right to appeal your case if you believe the judge has made a mistake. Voluntary departure means choosing to leave the United States on your own instead of being deported. You can lose your legal status and not be allowed to return to the U.S. for 10 years or 20 if it is your second deportation, or may never be allowed to return to the U.S. if you have a drug conviction or aggravated felony. Illegal return may result in federal conviction of a maximum of 20 years in prison. If you're detained, you may request release through a bond, but not everyone qualifies. If you do ask for a bond, you must show you're not a flight risk, not a danger to the community, and have little or no criminal record. Ask the judge for a separate bond hearing and bring letters of support and records of your time in the United States. The minimum bond is $1,500, though it's often higher. It's important to know that if you entered the United States through parole, like CPP-1 or CHNV, it is very possible that you do not qualify for a bond because you are classified as an arriving alien. Immigration judges are also denying bond to people who entered the United States without permission. If you are denied a bond, you may be able to file a case in a local district court, which is different than immigration court. This is called a habeas petition. This petition asks a higher judge to require the immigration judge to give you a bond hearing or to order ICE to release you from detention. You can do this yourself, but an attorney's help is strongly recommended. Detention is frightening, but you are not without rights. Learn more and prepare your family now. Visit our website, immigration.ablelaw.org/know-your-rights.